Everybody can be seated. Thank you. Good evening, and welcome to the 49th Annual Zuber Moot. My name is Rudra Krishnan, and I, along with Talissa Muhammad, Anne Mary Salama, and Natasha Daly, are the 2022 Zuber Moot Committee. We would like to begin the moot by acknowledging that Windsor law sits on the traditional territory of the Three Fires Confederacy, the Ojibwe, the Odawa, and the Potawatomi. To those of you virtually tuning in, we urge you to take some time to research whose land you sit on.
For the past 2 years, the Zuber Moot has been held online due to COVID-19. However, we are very excited to be hosting this time-honored tradition in person this evening. The Zuber Moot is a student-run internal mooting competition that provides second and third-year law students with an opportunity to practice their written and oral advocacy skills. The moot helps students develop an understanding of legal principles while learning about appellate litigation. The Thomas G. Zuber Moot Competition Trophy proudly displays the names of the 4 finalists who have competed each year for the past 48 years at Windsor Law. The tapestry of name plaques engraved on the trophy is a cherished reflection of the noble history of Zuber Moot appellate advocacy.
Tonight, we have 4 excellent advocates who will be arguing the appeal of the King and La France at the Supreme Moot Court of Windsor. Neil Lamarca and Andrew Boyes will be arguing on behalf of the appellant, the Crown. Tish Lewis and Abby James will be arguing on behalf of the respondent, Mr. Nigel La France. We are joined by a distinguished bench, the Honorable Justice Michael Tulloch of the Court of Appeal for Ontario, the Honorable Justice Steve Carrozza of the Court of Appeal for Ontario, and the Honorable Justice Maria Caricia of the Superior Court of Justice here in Windsor.
The Honorable Justice Michael Tulloch was appointed a judge of the Court of Appeal for Ontario in June 2012. Prior to his appointment, he served as a judge of the Superior Court of Justice in Brampton for 9 years. Prior to his appointment to the bench, Justice Tulloch was an assistant Crown attorney in both Peel and Toronto, beginning in 1991. In 1995, His Honor entered private practice as a criminal defense lawyer, which he continued until his first appointment to the bench in 2003. Notably, Justice Tulloch is also the author of the report of the Independent Police Oversight Review, which was published in 2017. This report examined the relationship between systemic racism against Black, Indigenous, and racialized individuals and the police. He is also the first Black judge to hold the position of sitting on the Court of Appeal. The Honorable Justice Steve Carrozza was appointed to the Court of Appeal for Ontario in April 2020. He is also the first Filipino-Canadian judge to be appointed to the Court of Appeal. Before being appointed to the court, he served as a judge with the Ontario Court of Justice in St. Catharines from 2009 to 2013, and with the Superior Court of Justice in Brampton from 2013 to 2020. Prior to his appointment to the court, Justice Carrozza was a staff duty counsel for Ontario Legal Aid in Toronto from 1997 to 1998, and from 1998 to 2009, he was senior counsel with the Department of Justice and the Public Prosecution Service of Canada, where his main area of practice was criminal law. Justice Carrozza is also a proud Windsor Law alum, as well as a former participant in the Zuber Moot.
The Honorable Justice Maria Caricia was appointed to the Superior Court of Justice in Windsor in 2020. Before her appointment, she practiced as a criminal defense lawyer for 30 years. She was also the president of the Windsor-Essex County Criminal Lawyers Association, where she participated in the development and implementation of policy and protocols. She has served on various committees, including the Criminal Court Modernization Committee, the Court Security Committee, and the Bail Committee. Justice Caricia is also a proud Windsor Law graduate and is currently a sessional instructor of the Criminal Trial Advocacy course.
We would also like to take this time to announce the winners of Best Factum and Honorable Mention Oralist from the preliminary rounds of the Zuber Moot. The Honorable Mention Oralist Award goes to Tredgar Shea and Judy Siraj. The Honorable Mention Factum goes to Andrew Boyes and Elena Finn Quinley.
Tonight has truly been a labor of love and the product of the hard work of many people, not just the committee members. We would like to thank Stephanie Biasi, Brittany Murdoch, Ann Dawson, and our faculty advisors, Professor Curis and Professor Little Kwan, for their unwavering guidance and support. We would also like to thank the 47th Annual Zuber Moot Committee, Nishit Karthikeyan, Sydney Brajak, and Olivia Troiko, as well as all of these spectacular preliminary judges who took the time out of their busy schedules to help Windsor Law students improve their advocacy skills. And not to mention all of the amazing mooters who took a leap of faith and mooted in person for the first time. We are sure it was no easy task and hope it was a worthwhile experience. We would lastly like to thank our Dean of the Faculty of Law, Reem Badi, who will now provide a welcome.
Good evening, everyone, and I formally and warmly welcome you to the 49th Annual Zuber Moot Competition. Thank you for being here this evening. As many of you know, the Zubers are a cherished tradition at Windsor Law. Every year, the competition is organized by a number of individuals, as you've heard, but led in particular by the 4 students who had excelled and moved on to the final round in the previous year Zuber competition. And this year, as you've met, our student committee consists of Anne-Marie Salama, Talisa Mohammed, Rudra Krishnan, and Natasha Daly. And in the finest tradition of Windsor Law, they've not only distinguished themselves as excellent students and as individuals with exceptional lawyering skills, but they've also gone on to dedicate their time to organize this event this evening, this competition this evening, and to mentor the students who have followed in their footsteps. So I'd like to thank our 4 student committee members, as well as their coaches, Professors Curis and Little Kwan. So thank you. This is our first time together in almost 3 years, and what a way to come back together. We are honored to host 3 distinguished judges today who will serve as the panel for this competition. Justice Tulloch, Justice Carrozza, and Justice Caracia. I'd like to thank you on behalf of the students, the faculty, the staff, and the alumni of Windsor Law for the dedication that you show to legal education and the confidence that you've shown in Windsor Law by being here with us today. Thank you very much. It is an honor to host you. Thank you. And I want to just close my welcome by addressing our 4 finalists of the 2022 Zuber Moot competition. And I'll ask our finalists to please stand. Please. So Neil, Andrew, Tish, and Abigail, you've already distinguished yourselves. And I suspect that you might be feeling a little bit of nervousness, perhaps some butterflies in your stomach. But I want you to know that you deserve to be here today. And I know that you were exceptionally prepared for this year's competition. And I'd like to ask everybody in the room to give you a round of applause before you even begin. Thank you. I know you'll be applauded at the end, but I wanted to acknowledge the work you've already done before you even begin this competition. And I'd like to invite you to savor the next few hours, because I have no doubt that they will be among your most cherished of law school memories. So again, everyone, thank you for being here this evening, and I turn it back to our Zuber Moot committee to get the competition started.
And now, without further ado, let us begin the 49th annual Zuber Moot. I will now call on our court clerk to begin the procession.
Oyez, oyez, all rise. The Supreme Moot Court of Windsor is now in session.
Good afternoon. You may be seated. So I just want to say how much of an honor it is for me and my colleagues to be here. This is your first public event, and it's really special to share it with you. And we know that each competitor has done the work ahead of time and have prepared endlessly, and we're here to participate in this amazing occasion. Okay, so we're ready, counsels. For the appellant, we have read the materials, and we're ready to hear your oral submissions.
Good evening, Justices. My name is Neil Lamarca, and alongside my co-counsel, Andrew Boyes, we appear on behalf of the appellant in this matter, His Majesty the King. The submissions put forth by the appellant will ask this court to consider a fundamental question. How far is this court willing to expand the applications of otherwise clearly defined rights? There are two issues for which I will be making the appellant's submission, and they will be argued in the inverse order as they occurred. I will begin with the events of April 7th, 2015, when the respondent's charge of murder and subsequent interrogation back at the RCMP office. The appellants will argue that upon the facts of this case, the clearly defined requirements for a second consultation are not met. The next issue is in relation to the March 19th date, which entails the respondent's alleged detention. The appellants will argue that the lower courts have held in a manner that creates a mere presumption of detention for individuals of vulnerable communities. And upon a proper application of the clear police conduct, the resulting analysis should militate against a finding of detention. My co-counsel will then address the Section 24(2) analysis, finding that the evidence collected against the respondent should not have been excluded. Justices, the facts of this case are listed at paragraphs 5 to 15 of the appellant's factum, but would the court like a brief overview of the facts?
Yes, please.
The respondent's home was subjected to a lawful search warrant. The officers awoke him and ordered him to get up and get dressed and to leave. He interacted with Sergeant Arrows outside of his home in which he accepted a voluntary offer to make a statement back at the station. 3 weeks later, he is charged with the murder of Mr. Yazinski and given opportunity to seek counsel, and then later in the interrogation confesses to the murder. Turning to the appellant's first submission, addressing the St. Clair principles, which can begin on paragraph 34 of the appellant's factum. The appellants respectfully submit that the events of April 7th do not meet the threshold for reconsultation. What St. Clair and its principles do stand for is a change in circumstances such that the choice faced by the detainee has been significantly altered, requiring new consultation. Our friends allege at paragraph 40 of the respondent's
Counsel,
factum.
Let me ask you this question. At the time when the police arrived at the respondent's home, they arrived there for the purposes of executing a warrant. Is that correct?
That is correct.
Right. And there was some belief on the part of the police that he was involved in this crime, in the murder.
That is correct.
So he had a jeopardy then, right from the outset of his interactions with the police. Isn't that right?
That is correct.
So if he had a jeopardy, wasn't it incumbent on the police officers to ensure that he was given his rights to counsel pursuant to Section 10B prior to any kind of interrogation or questioning?
If the police officers are to detain him, then yes, he is afforded the Section 10B protections. But the officers made it very clear to the respondent that he was not detained.
So you're saying that they went there to execute a warrant and he was free to leave?
That is what he is told. He's instructed that this is proper police procedure. It referred to the contents of the home, and he is otherwise free to leave.
Right. What about the principles of psychological detention?
Can you clarify the comments?
I mean, he's as I understand it, this is a young man, right?
Correct.
Yeah. From a marginalized background, indigenous.
That is correct.
Right. And he's not had very much experience with the police.
Correct.
Right. And the average person that's been interacted with the police in a situation like this, they would feel compelled to stay and answer questions, would they not?
That is correct. But
Right.
Grant holds.
So what makes this particular individual any different
Well,
from the average person?
just to begin at the outset, the appellants concede that the initial events that give rise to this encounter would lead an individual to feel focused or singled out for investigation. But Grant explicitly holds that this is not enough to turn on detention. And so it is the appellant's position that the clear instructions by Sergeant Arrows that every action would be voluntary proceeding should bleed into the analysis subsequent to and all the events that occurred.
Well, if that's the case, Mr. Lamarca, so your submission, I gather, is that on April the 7th, there was no change in circumstances that would require the second sort of rights to counsel. Have I got that right?
Temporally, yes, on
Yes.
April 7th, yes.
Okay. This is the submission that you're making right now.
Yes.
Well, my question is this: if in fact the appellant or the respondent in this case is not charged in March, but he's definitely charged in April, you definitely have a change in circumstances, don't you? Because at that point, his jeopardy surely is very much at issue, at least April. The April date is concerned. Am I right on that?
Of course, Justice. I would just like to make a quick clarification. I'm not suggesting that his legal jeopardy changes from March 17th from April 7th. We are suggesting the appellant submitting that no detention occurred on the events of March 19th.
No, I understand that, but the jeopardy though, he wasn't charged in March.
He was not. No.
Okay, but he's charged in April.
That's correct.
So it strikes me that if his jeopardy in that sense has changed, you've got a change in circumstances, don't you, in terms of how you interpret Sinclair? Because in April, he's definitely charged. So it seems to me that the interpretation of a change in circumstances has to be broad, if I could put it that way. What's your position on that?
The appellants submit that the respondent was given his initial consultation when he was charged with murder. And so his legal jeopardy does not change from that standpoint. On April, he is aware that he's being charged with the murder of Mr. Yazinski. He's given access to counsel, and he confirms that he received his advice and that he understood the rights as they were given.
But didn't it become obvious during the course of the interrogation that he really didn't understand the right to counsel by the questions he asked the police officer?
Yes, Justice. I think this turns to the crux of the issue. And it is the appellant's submission that as the transcript shows, his confusion is on the substance of the interrogation, whether he can employ the right to have a lawyer with him presently or not. And it is the appellant's submission that this is not a fundamental change in his jeopardy. He then goes on to confirm to Sergeant Arrows that he does understand his right to silence and his otherwise initial consultation is sufficient.
I thought Sergeant Arrows testified that in hindsight, it appeared that, there might have been some bad advice given. What do we make of that in terms of your submission that it's clear cut that, there wasn't really confusion here with respect to triggering a Sinclair second caution or second right to counsel?
On that submission, Justice, it is the appellant's position that in the Queen and Dacio, they hold that the police's conduct in terms of giving impairing advice on the advice to counsel that the detainee received, that could definitely trigger a change in circumstances. However, when we look at the transcript, Sergeant Eros immediately goes on to confirm from the respondent's reply that he does understand, that he doesn't have to answer any of his questions. He goes on to affirm by saying, yes, this is excellent advice. And so the objectable, the indicators of the observable indicators following that initial comment would not point to a depreciation from the respondent's initial advice.
Except it seems that he says he wants to call his father in order to get a lawyer. Doesn't he say something to the effect of, I have to call my father or else that's the only way I'm going to get a lawyer, or words to that effect?
Precisely. And it is the appellant's position that this is an implicit request for reconsultation, and it can only be done through a change of circumstances that the appellants would submit that is not the case.
But at that point, though, when he has to call his father, it was obvious to the police officer that, one, he was also still a very young man, right?
Mm-hmm.
And I think the question that he indicated to the officer was that his father was his only chance of getting a lawyer. Was the police not obliged at that point to at least stop the questioning until he was given the opportunity to speak to a lawyer?
In response to that question, I would like to turn the bench's attention to paragraph 38 of the appellant's factum, in which we address the presumption of sufficiency. And so from the Queen and St. Clair and the Queen and Willier, sorry, I will wait. From the Queen and St. Clair and the Queen and Willier, we see that there is a presumption that upon initial advice, that it is deemed adequate to provide the detainee with the ability and knowledge of how to exercise that right. And it is only, as the Queen and Willier holds, that the detainee expresses diligently and reasonably that the initial advice received is insufficient would that presumption fail. And so in response to the question, the initial consultation would need to be deemed insufficient, and merely requesting additional counsel would not meet that threshold as set by Willier.
Right, but the police has a purpose, right, for their interaction. You agree with me on that?
Sorry, state that again.
Police had a purpose for their interaction with this young man, right?
And during the interrogation?
Yeah, and what they wanted to do is to get some evidence to solidify the fact that he committed this murder. Am I right?
Correct.
Yeah, and so, they knew he was young, he was vulnerable, he had not very much experience with dealing with police officers, right?
Correct.
And yet you didn't think that it should have triggered the police officer to at least give him the opportunity to speak to his father and to get a lawyer, or to at least consult with a lawyer.
When the respondent extends and articulates his knowledge of his rights, it is deemed that is the constitutional minimum.
Right.
He is aware he's aware of his right to silence, and Sergeant Eros is not obligated to provide him with another opportunity for counsel
Unless there's a change in circumstances.
unless there's a change of circumstance.
But speaking for myself, it strikes me, what's the difference if the respondent here said, you know what, officer, that duty counsel or whoever I talked to hummed the entire time. You'd agree that that would be a change in circumstances, right? If the sergeant were aware of that information. That explicit type of scenario.
That would be correct.
So what's the difference if ultimately when you piece together what this respondent is saying, it amounts to the same thing? I'm not getting any advice. I got to talk to my dad to get a lawyer to speak to. Can't that inference be drawn? And that seems to me that's what the majority in the Supreme Court did.
I'd just like to clarify, and as stated before, it's the presumption that the initial consultation is deemed sufficient.
And you told us that it could be rebutted.
It could be rebutted
Right.
from Willier unless the detainee indicates diligently and reasonably that the advice is insufficient. And so it is the appellant's submission that requesting to speak with his father is not equivalent.
No, requesting to speak to a lawyer through his father. Does
Correct.
that not indicate someone that just does not understand their rights? And would that, by his conduct, not rebut the presumption?
No, it would not rebut the presumption once he goes to articulate to Sergeant Eros that he understands his rights and he knows he doesn't have to answer any of his questions. And so that is a fundamental submission on part of the appellants. What is needed under St. Clair is there to be a question on his understanding of his rights. But this is a confusion, a mere confusion on the form and not the substance of this right.
Now, your hedging your bets, is it amount to timing? So he's told diligently, he asked, can I speak to a lawyer through my dad? It might be a reasonable request. I appreciate your position. Officer says no, and then goes on. Now you understand your rights, right? Is that the timing here?
That is correct.
So is there something, I guess, suspect about that in terms of the respondent thinking it's hopeless? I'm not going to get to talk to my dad.
Just-
Just one point. I know that the time is almost up, but critically to this interrogation was the fact that he told the police officer that that the lawyer suggested that he told him to get a lawyer before the legal aid lawyer told him to get a lawyer before he continued talking, and that was voiced to the police.
Just, I see my time is up. Can I have a moment to answer the question
I'll
and then
give you-
conclude?
I'm the president, so I can give you.
Thank you, Justice. The advice from legal aid that he should have someone come down and speak to him face to face. That is part of the initial.
No, before he continued speaking to the police. That was the relevant.
I should get a lawyer. I
Yeah,
think it's
yeah,
something like that.
yeah.
I should get a
That is
lawyer.
the advice given from him by legal aid in the initial consultation. That is what we're referring to.
Right, and that was conveyed to the police officer that was interrogated.
That is correct.
Yeah.
But it is up to the respondent to actively pursue that. If he was deemed to not be sufficient with his initial consultation, he could have continued calling legal aid. He signals to the administrative officer that he is otherwise received his legal advice and is aware of his rights.
Before he goes into the interrogation.
This is
room,
correct.
though.
This is before. Just to quickly conclude, Justice, even though I wasn't able to sufficiently address all the points of detention,
No, you did good, so go ahead.
the appellants have brought forth the clear words of Sergeant Eros and the respondent in his dealings through both of the events. And it is quite clear that the respondent both understood his rights and his freedoms throughout both processes. My co-counsel will now address the 24-2 analysis, and unless I can be of any further assistance to the court, these are the appellant submissions on the first two issues.
Thank you, counsel.
Thank you.
Counsel.
Good evening, Justices. My name is Andrew Boyes, and I will be continuing the submissions on behalf of the appellant today. The appellant will be making two principal submissions relating to Section 24-2. First, if this court finds that a detention had occurred on March 19th, there is an insufficient link between the charter breaching conduct and the April 7th confession to warrant its exclusion under Section 24-2. Second, even if a proximate connection is found, the admission of any and all evidence against the respondent would not bring the administration of justice into disrepute. To the contrary, the reputation of the justice system would be in jeopardy if such compelling evidence of such an egregious crime were excluded from consideration.
So, counsel, is your submission then saying that it doesn't matter what the breaches are of an individual rights, as long as the individual have committed a crime that you deem to be egregious, then regardless of the breach of the police or the state, the evidence should be admitted?
No, Chief Justice, that is not the appellant's submission. However, the purpose of Section 24-2 is to uphold the significance of constitutional rights, but at the same time to balance them against the nature of the police conduct and the seriousness of the offense. In the case at hand, the nature of the police conduct was minimal.
Minimal.
Yes, Chief Justice.
Okay.
And the offense at issue is murder.
Right.
Very serious crime.
So this is the breach is that the police or the allegations of the breach is essentially that the police was able to incriminate in statement out of this particular accused in flagrant disregard to his charter rights under Section 10B. And would you say that's minimal?
Justice, the appellant submits that there was no flagrant disregard of the respondent's charter rights. If a violation is found, the police conduct was undertaken in good faith and the error was inadvertent. It was not reckless or willful.
Well, don't you think that, well, these officers were very experienced officers, right? They were homicide detectives, were they not?
Yes, Justice.
Right. And I would think that they have very extensive experience in interrogating accused individuals. And so they know to give them their rights to counsel when their jeopardy is an issue and their risk in given an incriminating statement. Did they not?
Certainly, Chief Justice. It's the appellant's submission that the police conduct reflected an honest belief that they did provide the constitutional rights to the respondent under Section 10B.
Well, except the respondent basically said, I need to talk to my dad. It's the only way I'm going to get a lawyer. So does that not undermine the good faith of the police officers? And what would have been the harm to let the accused call a lawyer again?
Justice, to answer your first question, the respondent's request to communicate with his father to seek additional consult with counsel emerged several hours into the police interrogation. It emerged after the respondent had already been given the right to consult with counsel, which he did exercise to communicate with counsel for 15 minutes. Justice, I'm sorry, would you mind repeating your second question, please?
Now I've forgotten it. What would have been the harm in letting him call a lawyer again? And does that really show good faith on the part of the police?
Justice, the appellant submits that Section 10B, while a significant constitutional right, no doubt, must be balanced against reasonable and effective policing. Justice, in the case at hand, the respondent did not clearly demonstrate that he did not understand his Section 10B rights. He did not clearly or unequivocally express that the advice given to him by counsel was insufficient. And in the case at hand, there's...
Well, I would say there was some equivocation if he's asking after his consultation with the legal aid lawyer that he speaks to his father so that he can get a lawyer. And secondly, that he conveyed to the police officer that the legal aid lawyer that he spoke to said, don't speak to the police any further until you speak to a lawyer. So that's not unequivocal. Sounds to me like he was equivocating.
Justice, the respondent's assertion that legal aid advised him to speak or to seek a lawyer was at the discretion of the respondent. So too was the length of the conversation. The police at no time stepped in and cut the respondent off from his conversation with his counsel. He could have spoken to counsel as long as he needed to sufficiently understand his legal advice. That was at the discretion of the respondent. Moving forward, the police did inquire as to whether the respondent understood his legal rights, and the respondent did reply in the affirmative. He said yes. It was only after several hours into the interrogation, when the implications of the respondent's crime dawned on him, that clarity somehow turned into confusion.
Well, but we're in on 24-2 at this point. So there's been a finding that there's been a breach, right? So the police did violate the respondent's 10B rights, not only once, twice. So I gather your position is on the first prong of Grant, that the seriousness of the police conduct is somehow at the lower end of the spectrum, if I have that right, Mr. Boyce?
Yes, Justice.
And so put against you is the fact that, yes, it's a murder. But that runs both ways, doesn't it? Because you would expect that 10B and the right to counsel would be really important if you're going to be charged with murder. We're not talking about a theft under here. It's murder. And not only did they breach it once, they breached it twice. So why isn't that sort of a pattern that would say, you know, the seriousness of the conduct here is pretty willful and flagrant? That's what's put against you. So do you have a position on that?
Yes, Justice. And the appellant respectfully disagrees that the conduct was willful or flagrant. If an accident is found on the police conduct, it was inadvertent and it was reasonable. Justice, the intricacies of the Sinclair factors are, to quote the dissent, the Court of Appeal of Ontario in the Queen and McColman.
Oh, well, anyway, go ahead.
The panel's not familiar with that case. At
Yeah.
least the president isn't.
I'm not familiar at all with it.
If I might quote from the dissent.
Oh. Go
Police
ahead.
officers are not expected to weigh debatable constitutional niceties in their encounters with the public. Justice, that is not to say that Section 10B is not an important constitutional right.
Well, let me push back on you. You know, maybe they're not expected to weigh the constitutional niceties on the roadside, but they certainly are when you have someone hours, in your words, in a room knowing that's a murder investigation and they're seasoned investigators. They know what to do. They know exactly what they're supposed to do. And so that's, I push back, and you can respond, that's very distinct, a roadside encounter than an interrogation that's going on in terms of a murder investigation.
Yeah, furthermore, the police officers are appendages of the state. You would agree with me on that?
Yes, Chief Justice.
And we entrust them with not only in upholding the law, but also ensuring that we as a society are kept safe. So they're deemed to know what our constitutional rights are. And they should be protecting our rights when they know that our rights are in jeopardy, or our positions are in jeopardy. So, I mean, it's all well and good for us to say, well, they're not entitled to weigh the niceties of constitutional rights of individuals when they're in difficult positions. And I, certainly give them some level of leniency in that regard. But what do you say about the fact that they are upholding their responsibility is to ensure that our rights are protected?
Justice, your point is well taken. Certainly to the extent as well that the police do have an obligation to protect the public from perpetrators of violent crimes. Now, as to the reasonableness of the police officers' belief that they had already fulfilled their constitutional obligations to the respondent, in the Queen and Sinclair, it is established that a single consultation with counsel will normally be sufficient to fulfill that obligation.
Can I ask you a question, Mr. Boyes? If the panel's not with you on the first two grounds of the test in Grant, do you concede that this statement, in fact, should point towards exclusion? Because by then, you've got a really significant, serious breach, and the impact, I think it's obvious on the rights would be fairly significant. So do you concede that if we're not with you on the first two grounds of Grant, that it's game over for the Crown?
Respectfully, Justice, the appellant does not concede on those grounds.
All right. And so on the third prong, I know you are in your written factum, which is excellent. You talk about the fact that this is murder; it's the most serious crime. But isn't there also another side of that coin that, as Canadians, we expect, even in cases of murder, that charter rights will be upheld, and there is some administration of justice promotion in excluding where there's egregious breaches. And so I'd like your thoughts on that.
Justice, if I can point to paragraphs 62 to 66 of the appellant's factum in relation to the third factor in the Grant analysis. The underlying question of the third branch asks whether the truth-seeking function of the criminal trial process would be better served by admission or exclusion of the evidence. Justice, there is no doubt that society values constitutional rights. However, as you have pointed out, society also values the prosecution of violent crimes. At the same time, the Alberta Court of Appeal found that the confession at issue was extraneous to the core of the Crown's case. Now, in the Queen and Grant, 1993, at page 261, the court held that evidence is more likely to be weighed in favor of inclusion where it's critical or crucial to a conviction. Justice, on the merits of the seriousness of the offense, that's already been established. However, the appellant submits that the confession at issue lies at the very core of the Crown's case, and without it, the case would be gutted.
Okay, so counsel, we understand that, and we know that there's a balance that always goes on in these situations. And in most cases, I would suggest in perhaps 99% of these cases, the evidence that is critical for the Crown's case is at issue. But as my colleague has stated, in this particular case, on the first and second branch of the Grant test, it's very obvious that the conduct of the police, would militate against admission. So it's a balancing. And would that not balance in favor then of exclusion?
Justice, perhaps if it was any other crime at issue, it might.
Oh,
But it's-
so you're saying then that it's okay for them to breach people's rights with respect to other serious crimes, but murders, when it comes to murder. it
The other way
hasn't-
around, it's
Oh,
okay to
sorry.
breach their rights on a murder.
Yeah,
Justice, the appellant submits that
sorry,
it's-
yes, of course.
Justice, I see my time is up. May I be
No, no,
granted
yeah,
an
finish
additional
it.
minute?
Yeah.
The purpose of Section 24.2 is a balancing exercise. And Grant holds that no single factor can be determinative in the analysis. Now, in the case at hand, the offense is a murder. The respondent killed Mr. Yasinski. That alone should weigh, when compared with the nature of the police conduct, in favor of admission. Justices, to briefly conclude, the respondent was at no time detained on March 19th, nor did he have a continued right to counsel after his arrest. His Section 10B rights were never violated. But if charter breaches are found, the Grant indices weigh for inclusion of the evidence. For these reasons, the appellant requests that this court allow the present appeal and uphold the decision of the learned trial judge. Unless I may be of some further assistance to the court, these are the appellant's submissions. Thank you.
Thank you. Respondents? Miss.
Good evening, Justices. My name is Tish Lewis, and along with my co-counsel, Abby James, we represent the respondent in this appeal, Mr. Nigel Vernon LaFrance. Justices, this case is about liberty, but specifically, and more importantly, this case is about protecting the liberty interests of an Indigenous teenager. Section 10B.
Well, it's not really about that, is it? Like, it's, your colleagues on the other side would say it's about ensuring that a murderer does not get off on a technicality. But anyway, go ahead.
Section 10B is the only shield Mr. LaFrance had to protect himself. What Mr. LaFrance received from the police, the only people who could give it to him, was a shield with holes in it, or no shield at all. I will be making the respondents' first and second submissions. That is, that Mr. LaFrance was psychologically detained on March 19th, 2015, and secondly, that he was owed and denied a second opportunity to consult with counsel on April 7th, 2015. My co-counsel, Ms. James, will then make the respondent's third submission, that the evidence should be excluded pursuant to Section 24.2 of the Charter. Mr. LaFrance was psychologically detained as per the tests set out in the Queen and Grant and the Queen and Lee. The respondents first submits that the particular circumstances of the accused, specifically his indigeneity and his youth, support a finding of psychological detention.
So when the police were executing the search warrant, they asked him to leave the residence. Is that correct?
Yes, Justice.
And he could have left. He didn't have to remain in the vicinity of the residence. No one said, stay here, we want to talk to you at that point. Is that right?
Yes, Justice.
And then he was approached by one of the detectives.
Respectfully, Justice, there's an intervening act there that needs to be considered by this court.
Okay, what is that?
Mr. LaFrance was ordered out of his home, and upon exiting his home, he realized his cat had escaped. As evidence of his own psychological appreciation of his liberty, he asked the police permission to retrieve it. At that point, the police had a choice. Their choice was to send an armed officer to chaperone Mr. LaFrance. That is the moment at which the respondents submit that the detention was crystallized.
I have to say, I find that a bit strange. I mean, it strikes me that most police forces, when they execute a warrant, they clear the house. They wouldn't allow someone to go back in to find their cat or their pet. And notwithstanding, I'm an animal lover, but at the end of the day, that sort of submission, well, an armed officer went with them, so he must have been detained. That cuts both ways, doesn't it? Because we have to step back and look, well, why are they in the house in the first place? Because they're allowing him to get his belongings. It strikes me that there's an argument that he wasn't detained. In fact, what they were doing was assisting him so that they could finish off executing the warrant.
Justice, just to clarify, when Mr. LaFrance realized that his cat had escaped, it was outside of his home.
Right,
And so the chaperoning took place outside of the home, not inside of the home.
right.
And so the police had secured the home. Mr. LaFrance had left. He didn't pose any threat. The police knew he had no weapons on his person, and he asked permission outside of his home, outside the bounds of the search warrant, to retrieve the cat. If Mr. LaFrance was truly free to go, he wouldn't have required armed supervision at that point.
Well, I mean, I guess that begs the question, why would they, well, first of all, in terms of the armed supervision, I mean, they're officers, right? They're good. You agree with me? They're armed. I mean, they're there. I guess my second question, building upon that, is, he is told to leave. And as my colleague, Justice Garcia points out, he could have kept going. Instead, he sticks around. He says, well, I think my cat's escaped, so let's look for it. That strikes me the opposite of detention, where, the officers could have said, you're not going anywhere. Don't move, which we often see in search warrants, whether it's a drug search warrant or a gun search warrant.
Justice, respectfully, don't move would be one way to convey to somebody that they have been psychologically detained.
100%.
The respondent's submission, however, is that when Mr. LaFrance asked permission to retrieve his cat, the police at that point could have told him he was free to go. They did not.
But they told him that just before that, when they went into his residence.
Yes, Justice. However, the Queen in Lee states that a detention can occur within seconds, and the Queen in Grant follows up to say that a single forceful act or word alone may convey to a detainee that they have been psychologically detained. It's a respondent's submission that Mr. LaFrance, as a youth, asked permission to retrieve his cat, and the police decided to take the benefit of controlling Mr. LaFrance.
So is it when's he detained in your view, Ms. Lewis?
When he goes to search for his cat, and the police send an armed officer to chaperone him.
So before that, he's not detained. You agree?
Correct,
And
Justice.
so it's when he asks if he could find his cat. I'm paraphrasing. That's when the detention crystallizes.
And the armed officer chaperones him to do so.
On that logic, then he says, "Can you help me find my cat?" And then he'd have to give him 10B at that point.
Correct, Justice.
Right? It just strikes me as being a bit unusual. I would have thought that the argument would be that he's detained as soon as they get in the house and they say leave out to 8 officers. But your position is that it's when he asks to go search for his cat that an officer had to give him 10B, give him rights to counsel?
Yes, Justice, because the respondents are willing to concede that the police were conducting a valid search warrant. As part of a valid search warrant, they are validly able to order Mr. LaFrance out of his home. Upon exiting his home, Mr. LaFrance may have seen 11 officers in tactical gear and marked and unmarked cars, but that was the extension of the already ongoing lawful search warrant. The respondents submit that it's the particular choice of the police to go past the bounds of the search warrant and to take control over Mr. LaFrance himself and send an armed officer to follow him where the detention crystallized and where Mr. LaFrance was owed his Section 10B rights.
But didn't the armed officer, did the armed officer leave him after that, after he found his cat? And then the detective began speaking with him?
Justice, as a finding of fact at the Court of Appeal of Alberta, they found that Mr. LaFrance was first chaperoned.
Right.
Then he was brought back by the officers. Once he found his cat, the officer didn't simply walk away. He was brought back to awaiting Sergeant Eros in his garage. At that point, Sergeant Eros asks for the voluntary statement to come to the police. The respondent's position is the detention had already crystallized.
So it was a continued detention by the sergeant.
Correct.
This is an objective test, right? Whether or not you're psychologically detained?
Yes, Justice.
Oh. And in terms of the objective view, looking at it objectively, so I've got to step in the shoes of a reasonable observer. That detention occurs when, they're assisting him to find his animal.
Justice, again to clarify, the Court of Appeal of Alberta did not use the word assisted, but rather chaperoned. And so that's an important distinction.
Well, it's the same thing in the sense of purpose, I guess. I mean, chaperone means, you're I guess, point taken. You're saying that it was more like guarding him as
Correct.
opposed to actively assisting him.
Correct, Justice.
All right.
And that as an Indigenous youth, chaperoned has a very different meaning.
So I guess you're then saying it's not just subjective, it's not just objective. There's a subjective element to the psychological detention, because one, you're focusing on his indigeneity, right? The fact that he's an Indigenous, well, he wasn't really a youth by legal definition. He was a young man.
Justice, 2 points on that question.
Yeah.
The Queen and Lee found that the characteristics that are common of adolescence, both neurological and psychological, can extend into a young person's 20s. And as such, Mr. LaFrance, a 19-year-old, is properly considered a young person. In fact, in the Queen and Lee, the detainees were all in their 20s. And throughout that decision, the court referred to them as young people.
Right, but there's a legal definition for youth, though, right?
Yes, Justice.
Under the Youth Justice Act.
Yes, Parliament needed to draw a line in the sand. However, it's open to this court to rely on jurisprudence and animate that definition, and that young people can be beyond the age of 18. And then to your second question, it is still an objective test. His indigeneity only factors in insofar as how would an Indigenous youth perceive being chaperoned by an armed officer. It's the respondent's principal submission that an Indigenous youth would feel psychologically detained at that point.
So, Ms. Lewis, I want to ask you a question about the second part of your argument. What occurred was it April 9th?
April 7th, Justice.
April 7th. So at that point, you'll agree that detention's not an issue. He was arrested.
Correct. He was
Correct.
properly arrested.
Properly arrested. Do you agree that he was properly advised of his right to counsel, the informational component?
The informational component, yes.
Was he permitted to exercise his right to counsel?
Yes, he spoke to legal aid for 15 minutes initially.
All right. So then your position is that subsequent to that, during the course of the investigation, the officer should have stopped the interview at some point. What point do you say he should have stopped the interview?
The respondent's submission is that as set out in the Queen and Sinclair, where there are objective indicators that a detainee misunderstood their rights, the police are to afford a detainee a second opportunity to consult with counsel. If I may, Justice, I'd like to direct this honorable court to the transcript between Mr. LaFrance and Sergeant Eros, which can be found at page 33, Appendix B of the respondent's factum. It's within the Supreme Court's decision in R.V. LaFrance. And I think it's
33 of your factum.
page 33.
Thank you.
I think it's important to go through the transcript and to see when and how Mr. LaFrance, as forcefully as an Indigenous youth could, assert his right. Mr. LaFrance first objectively indicates his misunderstanding by stating his mistaken belief that he believes that he is entitled to face-to-face legal consultation. Sergeant Eros says, "You have your opportunity, right?" Mr. LaFrance responds, "Well, no, they told me before I need to continue talking, I should get a lawyer." Sergeant Eros then acknowledges Mr. LaFrance's misunderstanding was reasonable by telling him the advice was misinterpreted. Sergeant Eros then says to Mr. LaFrance that he doesn't know who Mr. LaFrance is going to call or what lawyer he'll utilize. At this stage, Sergeant Eros seems at least agreeable to allowing Mr. LaFrance the opportunity to call a lawyer. His hesitancy now surrounds who Mr. LaFrance will call. Mr. LaFrance makes clear the connection between his request to speak with his father by saying, "That's what I mean. I need to talk to my dad first, because he's the only opportunity I'll have of getting a lawyer." So it is now clear to it's now clear to Sergeant Eros that Mr. LaFrance misunderstood his rights. He tells Mr. LaFrance that his rights, the advice he was given, was misinterpreted, and that his request to speak with his father was connected to legal consultation, because just prior, Sergeant Eros states, "I don't know who you're going to call. I don't know who you're going to utilize."
Is there a fine line between dissatisfaction with counsel and not understanding or confusion? So I'll put it to you, and you can push back if you wish, but isn't that also open for interpretation, this whole sort of passage here that suggests, look, I'm not really satisfied with the advice I was given. I was given advice, but I'm not satisfied. In those circumstances, is there a change in circumstance under Sinclair to provide a second right to counsel?
Under the predefined categories in Sinclair, a change in circumstance needs to be hinged upon an objective misunderstanding of one Section 10B
So it's got to be
rights.
about a misunderstanding, right?
Correct, Justice.
And so if I were to suggest to you that that's not a misunderstanding at all, that's just sort of dissatisfaction, and I want to talk to my dad about getting a lawyer, I don't like the duty counsel. Isn't that a distinct, that's not change in circumstance. That doesn't strike me as being a change in circumstance in Sinclair, as Sinclair would hold it.
Justice, even if this court is not satisfied that on the facts of this transcript, there was an objective misunderstanding on part of Mr. LaFrance. However, still open to this court is another principle in the Queen and Sinclair, which is that where the police undermine a detainee's understanding of their rights so as to distort it or nullify it, that also represents, Justice, may I? That also represents a opportunity for second consultation. Sergeant Eros tells Mr. LaFrance, I won't say that it's bad advice, well, it's misinterpreted. To Mr. LaFrance, again, an Indigenous youth, that may have conveyed to him that the initial advice that he was given was deficient, something that the Queen and Sinclair says arises a second opportunity to consult with counsel. If I may have a brief moment to conclude the respondent submissions, Justices.
Yes, go ahead.
Mr. LaFrance was denied the shield of legal consultation not once, but twice. The police failed to exercise the necessary levels of caution and care that are to be afforded to young detainees. As such, the evidence obtained by the police is properly under review by this court. Unless I can be of any further assistance to this court, those conclude the respondent's submissions with respect to the Section 10B issues. Thank you.
Thank you, counsel. Afternoon, counsel.
Good evening, Justices. My name is Abby James, and I appear on behalf of the respondent, Mr. Nigel Vernon LaFrance. The respondent will now establish that the evidence collected by the officers in connection to the two infringements of Section 10B on March 19th and April 7th of 2015 should be excluded from trial. Because of the pattern of violations, the vulnerabilities of Mr. LaFrance, and the egregious behavior of the officers. The evidence should be excluded from trial as its admission would bring the administration of justice into disrepute. To do this, I will take the court through a Section 24(2) analysis as set out in the Queen and Grant. The learned Supreme Court of Canada.
Ms. James, I think for myself anyway, and I think you can rest assured this panel is really familiar with Grant. So I want to focus you on one point, and I'd like your thoughts on it. Your colleague, Ms. Lewis, had, advised us that, it's your position that really dealing with the March breach, that the detention occurs not when they're executing a search warrant, because they're validly executing a search warrant. They're entitled to do that. But it only happens when it's outside of the residence, not inside, not even when they told them to leave. So if that is the case, it strikes me that that's not necessarily a willful or flagrant breach, because it happens in the context of him asking for help with his cat. I appreciate the Alberta Court of Appeal says chaperone, but context is important. The whole thing comes about as a result of his request. So my question to you is, that strikes me as something that isn't willful or flagrant. So is it fair to say, as you pointed out at your opening, that this is just an egregious sort of pattern of conduct? That strikes me as being a kind of a technical breach here. I mean, they were looking for his cat.
Justice, the officers' belief on March 19th that there was no detention and that they did not have a duty to inform Mr. LaFrance of his Section 10B right to counsel was not reasonable. The Supreme Court of Canada in the Queen and Lee defined acting in good faith as conduct with which is consistent with what the officers subjectively, reasonably, and non-negligently believed to be the law. It was not a reasonable error given the sheer number of facts indicating that a detention had occurred, the length of the questioning, the fact that they changed location to a police station, the 11 officers present at the scene where the detention began, and Mr. LaFrance's Indigenous status, his age, his small stature, and his low level of sophistication all point to there being a psychological detention.
How do you square that with the several occasions that the officer says you can leave at any time? You're not in fact required to do this. But we'd like to ask you a few questions. I mean, I appreciate that there is some discussion in the courts below about the weight that's to be given to that. But I mean, surely that cuts against this argument that that's an egregious breach of 10B when they're telling them you can go at any time.
Justice, although the officers said with their words that he was free to go, their conduct spoke otherwise. And given the significant power dynamics that were at stake during this encounter, I would especially point towards the vulnerabilities of Mr. LaFrance, increasing the seriousness of that power dynamic that was at play, that there was a detention.
Yeah. I guess what I'm having problems with, speaking for myself, is that he's told to leave. He then doesn't feel that uncomfortable that he can go approach an officer to help him find his cat. And as my friend my colleague Justice Garcia points out, it's only one officer, the sergeant, that actually approaches him at that point. It's not as if a tactical squad escorted him down to the police station, and then it strikes me that if you step back and look at it, other than the fact that we can take into account obviously the fact that he's Indigenous and the history there with respect to police. I mean, looking at it though, stepping back, he doesn't seem that vulnerable to me when I look at what his actions were vis-a-vis the police.
Justice, Mr. LaFrance's statements to the police in that specific regard may indicate that the respondent concedes that they may indicate that he was verbally acquiescing to what had occurred. However, we have to look to the power dynamics that were at play here and the conduct of the police officers.
But would the police have known, counsel? Because if he verbally seems to be at ease in the sense that he's able to communicate with the police and respond and interact with them, I appreciate he's smaller stature, he's Indigenous, he's young, he looks young, they're experienced detectives, but they're also telling him you can leave, you don't have to stay. Was there anything that the police should have obviously been aware of? Do you understand my question? What they should have seen or
Justice, the officers should have considered the totality of the circumstances as the detention continued. I would specifically point to the fact that they changed.
But if they don't think that there's a detention, I mean, why should they consider anything more than what they were doing? They were there just to execute the warrant. And in their view, they're going about their business, executing the warrant. They're having interactions with this particular individual. But at no point in time did they tell him that he was under detention, right? And as my colleagues rightfully say, their conduct almost indicated that he was free to go about his business and move about. They'll even help him to look for his cat.
Justice, it is the respondent's position that there was a detention when we looked to the specific facts that there was a 3-hour length of questioning and a change in location. Those facts indicate, and they reasonably should have indicated to the officers, that a detention had occurred, and that therefore they had a duty to provide Mr. LaFrance his Section 10B right to counsel. I will rely on the respondent's factum for the first branch of the grant analysis and move to the second regarding the impact of the breach on Mr. LaFrance's protected charter rights. This begins at paragraph 41 of the respondent's factum.
I know you want to take us to the second, but I want to get this question before you run out of time. So if we agree with you that there's, the first two prongs of grant are in fact in your favor, is there room still on the third prong to say, look, this is a murder at the end of the day, and it's pretty crucial to have this, having the panel's very experienced with murder trials, we know what a confession can do to the case. Is there room essentially to say, look, the administration of justice requires that this statement be admitted nevertheless because of the truth-seeking function of a trial? It's a murder.
Justice, the respondent concedes that this case involves a very serious offense and that this will increase the public's interest in adjudicating the case on its merits. But society also has a vital interest in a justice system that is beyond reproach, particularly where the penal stakes for the accused are high. And this was held in the Queen and Grant and the Queen and Harrison.
Yeah, but the average person on the street are thinking that the court's just giving this guy a break, let him off on a murder charge, when in fact, he committed the murder. And there's some technicality that the police innocently committed. And, wouldn't that bring the administration of justice into disrepute as indicated by your friends?
Justice, given the seriousness of the conduct that we saw from the officers and the fact that there were repeated infringements of the Section 10B right of Mr. LaFrance, it is important that we ensure that the general public are able to view the justice system as one that is beyond reproach and to feel that they are able to have confidence in their charter rights, even when they are under the charge, such as was in this case. Returning to the impact of the breach on Mr. LaFrance's protected charter rights. The Queen and Harrison define a serious breach of a charter as one where the interests protected by that right are seriously compromised. The protected interests of Section 10B of preventing false confessions, unfair self-incriminating statements, and wrongful convictions were seriously compromised by the officer's behavior in this case. Mr. LaFrance's indigeneity and his young age further increase the impact of the breaching behavior because it intensifies the power dynamics in both encounters with the police.
Does the fact that he did speak to counsel mitigate that? So it's not as if it's a single transaction in the sense that taken to the station, from the house, and you say there's a 10B breach, and confesses right then and there. In fact, what happens is there's a gap in time. Now, I'm not convinced that that is not obtained in a manner, but at the end of the day, isn't it still relevant that there's a gap in time and he does speak to counsel? So when we talk about the impact on his charter rights, doesn't that mitigate the impact because he did speak to counsel and was given some advice?
Justice, to address your first point regarding the gap in time between March 19th and April 7th, it is the respondent's position that the evidence still had an impact on both the case and the investigation, given the fact that a significant amount of evidence was collected on March 19th, and that while this evidence was in the police's arsenal, they then proceeded to arrest him on April 7th and question him.
But when you say the evidence is collected, that's collected pursuant to what your colleague has conceded is a valid search warrant.
I am pointing towards the evidence that was collected on March 19th during the questioning that
I see.
occurred,
Okay.
and the physical evidence that was collected after that
Right.
detention occurred. It was blood, fingerprints, clothing, and a cell phone.
Okay. Well, it doesn't break the chain of circumstances. I appreciate your answer, but surely this is not a situation where he was given no legal advice, because there was legal advice given.
Justice, although legal advice was given, it was insufficient in providing Mr. LaFrance the ability to make a meaningful decision about whether or not to cooperate with the police, because given the circumstances and the facts that are known, there was a changed circumstance that Sergeant Arrows should have been aware of when it became clear that he did not understand his Section 10B rights. Returning to the impact of the breach on Mr. LaFrance's protected charter rights. Sergeant Arrows' charter breaching behavior was attenuated by the fact that he attempted to undermine the solicitor-client relationship when he said, and I quote, "I won't say it's bad advice, but it's maybe misinterpreted," end quote. Police statements that have the effect of damaging an accused's confidence in their counsel are prohibited under Section 10B, as was held in the Queen and Burlingham. This was not a fleeting infringement. This was a 3-hour psychological detention at a police station. This was repeated infringements of Mr. LaFrance's Section 10B rights. And this involves the risk of a lifetime in prison.
Can I ask you a question factually? I read that passage that your colleague took us to, the misinterpretation of advice. Isn't it fair to say that that also could mean that what the sergeant was driving at was having a lawyer in the room, as opposed to undermining the legal advice he was given? What do you say about that?
Justice, I see my time is up. May I have a
Sure.
brief moment to answer your question and
You may.
conclude? Thank you. Justice, in response to your question, in terms of whether or not that statement could be indicated as pointing towards the misinterpretation of Mr. LaFrance when he made the statement that he wished to have a legal aid lawyer present with him, the respondent would point the justices to the fact that this further indicates that he did not understand the advice that he had been given that it would not have been reasonable for the legal aid officer or legal aid lawyer to be coming down to the station to sit with him while this was occurring. So this further indicates that there was a changed circumstance. given that Mr. LaFrance did not understand the advice that he had been given by counsel.
Okay, I understand.
To conclude, the officers breached Mr. LaFrance's Section 10B rights twice during the course of their investigation. The evidence that was collected in breach of Section 10B must be excluded from trial. The seriousness of the conduct, the impact of the breach on Mr. LaFrance's protected charter interests, and society's interest in having meaningful charter rights and a justice system that is beyond reproach demonstrate that the evidence must be excluded. Given the significant power dynamics that the police and the state create, given Mr. LaFrance's vulnerabilities, his age, his physical stature, his Indigenous status, and his low level of sophistication with the law, and given the interests that Section 10B shields the accused from, and the liberty that is at stake, the evidence should be excluded. Including this evidence would signal to the public that the justice system's loyalty lies with the police over society. This appeal should be dismissed. Unless I may be of some further assistance to the court, these are the respondent's submissions. Thank you.
Thank you. Thank you, counsels, to both sides.
Justice is needed to ask the appellants if they'd like to exercise the right of reply.
Great. Thank you, Mr. Clerk. Reply?
The appellant will not exercise the right. Thank you.
Thank you, counsels.
It's a good answer.
Yeah, perfect.
I guess we reserve.
Right, okay, so counsel, we thank you both for your very able argument on this appeal. The panel has agreed to reserve our decision, and you will have our decision in due course. Thank you.
It is now time for the justices to deliberate. Justices, the clerk will now call the court to recess and then will then lead you to your chambers. Thank you.
All rise. Supreme Moot Court of Windsor is now recessed.
You may be seated. Congratulations to our 4 incredible finalists. A job well done. Now, I would like to invite Appellant 1 from the 48th Annual Zuber Moot, Talissa Mohammed, to give Appellant 1 from the 49th Annual Zuber Moot, Neil Lamarca, a token of our appreciation. Now, I would like to invite Anne-Mary Salama, Appellant 2 from the 48th Annual Zuber Moot, to present Andrew Boyes, Appellant 2 from the 49th Annual Zuber Moot, with a token of our appreciation.
And now the second respondent from the 48th Annual Zuber Moot will now present the second respondent from the 49th Annual Zuber Moot with a token of our appreciation. And lastly, the first respondent from last year's moot will present a token of our appreciation to Tish Lewis, the first respondent from this year's moot.
Hello, everyone. Thank you again, everyone, for coming. Congratulations to our 4 finalists. Professor Little Kwan and myself, I'm Professor Kiros, we're faculty advisors, and we are here to just express our thanks to the Zuber Moot Committee 2022, who've worked so hard over the past 5 months to prepare the preliminary rounds and this evening. So we have a small token of our appreciation from Windsor Law to our wonderful Zuber Moot Committee 2022. So the first gift to Talissa Mohammed. The second gift to Anne Mary Salama. The next gift is for Rudra Krishnan. And of course, and our last gift is for Natasha Daly. Thank you so much.
And now I'd just like to thank our Law One volunteers for all of their hard work. And last but not least, I want to thank everyone here in the auditorium for coming in person to watch this amazing moot. So thank you so much.
So now, as the judges deliberate, we will have our intermission. Should you choose to leave this courtroom, we ask that you return within 5 minutes. Thank you very much. Could everybody please take their seats? Court will resume shortly.
Okay, just want to thank you both sides for your very able argument. I can indicate to the court that we have arrived at our decision. The appeal is dismissed. I can also say that we've also arrived at the decision with respect to the top two oralists. I think just before I say that, I think you guys were amazing. All four of you were incredible. And I can say this without any equivocation, that you could appear in our court like tomorrow, right? And it would be a delight to have you. And I've been a judge now for 20 years. And Steve, I think we see all sorts of councils in front of the Court of Appeal, and I was on the Superior Court.
Yes.
And I think by far you guys are superior, so, and you'd agree.
And I was just so impressed by the poise that you all showed. We fired a lot of questions. You barely got your argument out, but you were able to answer the questions and stick with it. So that was really impressive.
Yeah, you showed a command of the facts of this case. All of you did. You showed a command of the law, an understanding of the law. You were responsive and respectful to the court, to the questions that were asked. None of you really backed down. I mean, but you know what? Like, you're good advocates. So I hope to one day see you before us. So having said all of that, Steve, do you want to say something?
I echo my colleagues' comments. I was in the Zuber Moot and I flamed out at the preliminary stage, and it traumatized me for many years. So I'm glad to be back to give it to the lawyers, advocates. I'm kidding. But the only other point I would make is in our courts, we typically don't have, hundreds of people behind you typically watching unless it's a really high profile case. I think it takes a lot of courage to get up and do this in front of this type of wide audience. You should be very proud of yourselves. And that's what makes litigation such a joy. It's an art, and you work on it, and you're well ahead of the game. I can tell you that. So congratulations to all of you, your coaches, your colleagues, and your families.
I was going to say, just to add, you guys are real credit to this institution, to the University of Windsor Law School, and to the faculty here, and certainly to your parents and your families, all of you. So congratulations again. It was a real pleasure to be here and to participate in this and to witness the level of excellence that's being produced here at this university. So anyway, having said all of that, unfortunately, all of you could not be the top oralists, right? We were given certain constraints by which we had to work within. And so you're all winners, but two of you sort of just eked out on top of the others. And I'd say Trish Lewis, you were amazing. So you were one of them. And Neil Lamarca. And Neil, you withstood the fires like right from the outset. And you still survived and maintained your composure and maintained your argument. But having said that, like we all said, each of you were incredible. Right? So.
I just want to say, remember this, because judges don't typically talk to lawyers this way after the hearing.
Right.
So this is about the only time you're going to get the Court of Appeal or the Superior Court of Justice saying that was excellent advocacy.
Yeah.
That's very true. That's the only
Complimenting
time you'll get positive feedback.
Yeah.
You never do. And but it's good to know that and to hear, right? And normally what we would do is we would go back. We may or may not reserve the decision, and it would be mailed out to you. And our staff would notify you of what the ultimate decision is. So anyway, this is a real treat. And both Steve and I and my colleague, I'm just meeting her for the first time.
That's right. We just met for the first time.
But it's a real pleasure. to
Thank
sit
you.
with
It was a pleasure to meet you as well.
Yeah, and we would like to be back here. So anyway,
I think
Maybe next
Natasha
year.
wants to say something.
Oh, sorry.
That's okay. That's okay, Your Honor. Just a few full closing remarks. Congratulations once again to our two top oralists. You all truly did an incredible job. And I definitely echo what our amazing and distinguished bench has said in terms of the treat that it really is to be able to receive feedback from judges at this stage of your legal career. So truly, may it encourage you and may it encourage the other first years and second year law students that are currently attending this moot with us to engage in the Zuber Moot next year, as this will be your committee and your coaches that will help you get to this level as well. Lastly, just before we officially close the 49th annual Zuber Moot, I'd like to invite my fellow committee members to present just a short token of appreciation to our distinguished bench. We have some gifts for your honors. So thank you once again for your time, especially Justice Carrozza and Justice Tulloch for coming all the way from Toronto, early and late flights. We appreciate it. We truly do. And thank you, Justice Carrasier, for joining us.
I came
We
all
really
the way from
appreciate it.
downtown.
Thank you so much. Let's give them a round of applause.
Thank you. That's very sweet.
Thank you
very much.
All right, and without further ado, that concludes the 49th annual Zuber Moot. Thank you all. Court is now adjourned until next year. And at this time, I'm going to ask the judges to approach the trophy, as well as our finalists to also approach the trophy for some photos. And then you can retire back to judges' chambers for your specific individualized feedback. Have a wonderful evening, everyone, and stay safe.